I trust that you have had a good day, and welcome back to our class, our discussion lessons on legal issues in hospitality and tourism management. My name is Dr. Mutinda, and it will be a pleasure to go through this together with you. As we continue with our discussions in this lecture, today I wish that we look at three main topics. That is, we'll finalize on the law of contract that we have been working on. And two, we'll also look at the law of torts. And we'll finalize with a discussion on the legal relationship between the hotelier and the guest. And so welcome. Now we'll start with the law of contract. All throughout our discussion on this topic, we have noted in our previous lessons that when it comes to a contract, here we are talking about a legally binding agreement between two parties. And we saw what are the elements that will be required for a contract to be termed as legally binding. And so today then we will be looking at how do we end a contract, or how do we discharge of a contract. And so a contract may be ended or may be discharged through a number of ways. And that's what I will summarize today as we bring this to a close. One, through performance. That is where the parties have done their parts. Each one of the parties has fulfilled their mandate under the contract, and that brings it to a closure. And secondly, the two parties may agree to end the contract. And so it becomes another way of discharging a contract where it's through agreement between the two parties mutually. And thirdly is through the operation of law, and we also look at the fourth one being impossibility of a performance. And so the other one is the breach of contract, the contract, and the sixth one is through frustration. I'll mention about performance, and here we're talking about where the two parties have completely done the obligation to one another, and so that brings a closure, as I mentioned, to the contract. Secondly, as I said, the two parties may agree to end or to discharge of their duties or their obligations under the contract. I've also mentioned the third one, the operation of the law, and in this case is where the law comes in to bring a closure to the contract that has been existing between the two parties. For instance, if one of the parties becomes bankrupt, as we had noted, bankruptcy is one of the key reasons that to make one of the parties to lack capacity. And so when that happens, therefore, the law may come in and bring to a closure or to a discharge that contract. The other one is, as I mentioned, about the possibility of performance, where it becomes impossible for the contract to be performed or for the parties to be able to discharge of the obligations under that particular contract. And so in that case, therefore, it automatically, the party automatically discharges of their mandate or their obligation under the contract, and that brings it to a closure. But what we need to be able to note, that the possibility must be something that renders performance totally impossible, or something that is unexpected, which changes the circumstances so radically that the contract will have to become fundamentally different from the original contract that had been signed. And that's the thing that we are noting under this. The other one that we talked about is through the breach of the contract. And the breach of contract, we're talking about where one party fails to honor or to live up to the obligation of their obligation under this contract. However, it is rarely as simple as that we are seeing, but we won't be able to look at this further as we consider the matter to do with the breach of the contract. The other thing that we have also mentioned is through frustration, and this is a case where a contract comes to an end when some external event that is outside the control of the parties to either party to the contract, which will render the performance of the contract impossible. And this is what we regard to as frustration. So those are the ways that a contract can be brought to an end, or it can be discharged. Now, in the case where one party breaches the contract or the party fails to live up to the obligation under the contract, then the other party may seek remedies for breach of that contract from the other party. And so what we're going to look at here is then what would be the remedies for breach of contract when that occurs. We have four main ways of resolving this. One is the simple one, the self-help, where we expect the party that is injured or that is unhappy to be able to approach the other party and talk to them to honor their part. Secondly is do the government help, and here we are looking at seeking assistance with the government structures that do exist. And the third one is the use of alternative dispute resolution, and here we are thinking about either mediation or through arbitration. The fourth way of seeking redress to this is through courts or tribunal help. And under this, then, what we have, the courts have four options that they can be able to take in as they look at this. One, the court may order for rescission. In this case, then, what the court is doing is actually to revoke the contract. Also, this now brings an end to the contract. The court comes and says it can no longer continue. And secondly, the court may award damages, and here we think about payment of money for the party that was injured within this contract because of the failure of the other party to honor their part within the contract. So that is what we regard to as the damages. What we need to note under the damages is that the aim of the award that the court is going to be able to give, monetary in terms in that case, is meant to place the wronged party in the same position as they would have been if the contract had been performed properly. So it is not meant to profiteer the wronged party, but more about restoring this party to where they would have been if the contract was fully performed as expected. The other way that the court can also come in is through ordering for specific performance. This is where the court may consider that monetary awards may not be sufficient enough to award or to compensate the party that is wronged. And so in that case, then the court may want to insist that the other party complies strictly with the contract that has been made. And this is what we are saying, the court requiring specific performance. And the other one that can also happen in this case, the court may also prohibit penalties for the breach of contract. Now, ideally, the parties to a contract are allowed to settle the matter out of the court. But in the cases where the two parties may have agreed and the court regards that what was agreed amounts to a penalty, then the court may come in that case and stop or prohibit the payment of that amount that is regarded to be a penalty. And so those are the options that the court may be able to take within this case. And that then brings me to the second discussion lecture today on the law of torts. Now, the tort law, as we saw at the point we were introducing this course, is a branch of law which covers civil wrongs. And these civil wrongs are thinking about wrongs between individuals. Examples of this we gave them in our introductory class, things like defamation, trespass, and among many other transgressions that may occur out of the day-to-day relationship between individuals and between the parties within the society. And so that's what we cover under the law of torts. Now, torts are classified into three. We have the torts that will arise out of negligence, and these are civil wrongs that will be caused by the negligent behavior or failure to practice due diligence by one party. The second category is the torts that we regard as intentional torts. And these are torts that will involve a deliberate attempt by one party to harm the other. We regard these as intentional torts. And the third one is the strict liability. And these kind of torts majorly cover products where a manufacturer of a product may actually be held liable all through the lifetime of that product, so long as it can be able to cause any injury. So you are held strictly liable to ensure whatever you manufactured will continue functioning and will not be able to harm people as it continues in its lifetime. So that one we regard to it as a strict liability. Under the intentional torts, I wish to give some examples. We have the infliction of emotional distress, and this is an intentional act that will amount to extreme and outrageous conduct, and this results in severe emotional distress. If one party does this to another individual, then that amounts to an intentional tort. We can also have defamation, and here we are defaming the character of an individual, so in wrongly hurting a person's reputation. That we call it defamation. The other one is the invasion of somebody's privacy. And what is this we're calling privacy? Because the law regards that an individual has right to solitude and freedom from prying public eyes. And so any act that will invade or will go against my right to solitude and freedom from prying public eyes, then amounts to privacy. And we have a few examples that we have given there, what exactly amounts to this, or what can qualify to be regarded as invasion of privacy. So things like the use of a person's name or pictures or other likeness for purposes of commercial usage without their permission, that will amount to invading the privacy of that person, intruding into an individual's affairs or seclusion in an area that the person reasonably believes or considers to be their privacy. That again also is part of this. Or even the publication of information that places a person in a false light. We also have public disclosure of private facts about an individual that an ordinary person will always find objectionable, or that amounts to invasion of privacy. Again, misrepresentation also comes in here, where we think about one person leading another to believe a condition that is different from the condition that actually exists. So that amounts to misrepresentation, which can also we can also talk about it being a fraudulent misrepresentation. And when we talk about fraudulent misrepresentation, this is where there is going to be an intentional deceit for personal gain. So those are part of what we're regarding as a misrepresentation. The other intentional tort may be trespass to land or trespass to personal property. That's also another one that we have there. And so all those forms are examples of intentional torts. Now, from our practice within the hospitality and tourism industry, the area that becomes more important to us is the area of unintentional torts, which we regard to as a negligence. And this is, as you have mentioned, the tort of negligence, which will occur when someone suffers injury because of another person's failure to live up to a required duty of care. And that's what we are calling the negligence in this case. So your failure to live up to a standard of care may be either as an act of commission or as an act of omission. Any of the two will amount to this. But when it comes to determine whether negligence was there, or when the courts are examining a question of negligence, then one should be able to ask the following questions. One, whether the defendant owed a duty of care to the plaintiff. And secondly, whether whether the defendant breached that duty of care. And thirdly, whether the plaintiff actually suffered a legally recognizable injury as a result of the defendant's breach of duty of care. And finally, whether the defendant's breach caused the plaintiff's injury. So those are the four criteria that are usually used when we want to decide, when the court wants to decide on whether actually the tort of negligence actually occurred in this kind of a case. That's what we need to be able to mention under that. Now, hoteliers have a liability that is inferred on them under the occupier's liability. And that's what I want us now to be able to look at today. And the occupier liability is chapter 34 of the laws of Kenya of 1963. Now, what this occupier's liability is all about is that it holds occupiers of premises to have a duty, or they owe a statutory duty of care to their lawful guests who come to their premises. And so in this case then, we need to be able to understand who is this lawful visitor as far as the hotel is concerned, and what kind of duty do we owe to these visitors. Now, the law requires, as I mentioned, that under the common, an occupier of premises will owe the same duty, the common duty of care, to all the visitors who come to their premises. And as I was saying, that addressing the issue of the lawful visitor, a lawful visitor is a person who has permission of the occupier to enter the premises. In other words, the visitor has been expressly or implicitly invited to the particular premises. Now, to that one, the occupier of that premises has a lawful duty or a legal duty to ensure that person is safe. So you owe them duty of care. But there are a few restrictions to this Occupiers Liability Act and the defenses that may come in there. So what we are having in mind here, assuming you are the occupier of the premises, and this is now the hotelier, and you have your lawful visitors who have come to your premises, and they claim the matter of that you owe them duty of care and the occupiers liability. What would be your defense, and what exactly can you be able to do as far as this is concerned? One is the so-called warning notices, and these ones we must have seen enough of them, where you come to a hotel and find a place you have written is parking, but we still tell you that cars are parked at owner's risk. We go to the swimming pool, and even the swimming pool, we also tell you there is no diving. Now, all those are part of the notices that we are talking about here, the warning note that we are going to be able to put. But what we need to be able to note here, a warning notice must be readily understandable and clear symbols that will explain the danger. That is the qualifier for any warning notices, for them to be effectively regarded as remedies under the Occupiers Liability Act. Secondly, there is the issue of liability to children. Now, you may go around and put your warning signs and give your warning notices, but the law requires and expects that not all guests to a hotel will be adults. And this is for a fact. So what will be expected is that under the Occupiers Liability Act, it puts liability or requirement or obligation on the occupier of the premises to ensure that they understand that children require a higher degree of care as far as this law is concerned. And so you as an occupier must be prepared for children to be less careful than adults. So as much as you put our notices, we also are mandated to ensure that kids and children are still safer within the premises. The third remedy is liability towards employees and especially subcontractors. And the law itself regards that the occupier may expect a person who is in the exercise of their calling will appreciate and guard against any specific risk that may occur to them. So if one is a contractor, is a specialist, we expect that they are professionals and they are knowledgeable within their area. And so they should be able to take care of themselves not to get injured in their course of duty. And that's, in that case, therefore, the occupier may not be liable for any injury that will occur to the contractors or to the specialists who are working on site there. The fourth thing is what we call voluntary and unfit injury. In this case, what we're looking at here is a so-called voluntary assumption of risk. And this is captured under Section 5 of the Occupiers Liability Act. And what that one provides is that the common duty of care does not impose on an occupier an obligation to a visitor in respect of risks that they have willingly accepted as having occurred by the visitor's own action or omissions. And so in that case, then, the requirement under voluntary and unfit injury is that the occupier will be free of obligation under this law. And the fifth one is contributory negligence. This is where visitors have contributed to their own injury. So they sustain the injury, yes, but they contribute to their own injury. In that case, therefore, the damages to which they are entitled may be reduced because they contributed to their own injury. So those are some of those that you can be able to take under that, and I wish to bring that one to a close at that very point. And then we turn to our lesson number 3, the hotelier and the guest. Now what you're looking at at the very point, we are looking at the relationship that will exist between the hotelier, that the hotel manager or the innkeeper, and the visitors and the guests who are coming to that particular hotel. What legal relationship exists between the two? What we're going to be looking at here majorly is what are the duty, of the innkeeper, and what are their rights. Now, an innkeeper has a number of duties that they are expected by law to perform. I need to mention that by law, an inn or a hotel is a public place. That is expected to meet a number of obligations towards the public. And one of them is that the innkeeper has a duty to receive guests. In other words, to provide accommodation. And so this is the very first and most important public duty of the hotel, receiving guests. But we need to also mention that the duty is not absolute. It is subject to lawful excuses. We may need to look at what are some of these excuses that may prevent the hotelier or the innkeeper from fulfilling this duty. One, it is expected that the prospective guests may actually be denied accommodation under the following reasons. Number one, if the person is unwilling or is unable to pay for a room or to pay for other establishment privileges. And number two, if the person is visibly under the influence of alcohol or under the influence of other drugs, or even creating public nuisance. And that reason why a hotelier may deny accommodation to a visitor or to a guest who comes around is if the person's use of a room or accommodation will violate the facility's maximum capacity. Here you think about the issue of that you are fully occupied. So if there's no additional space, there's no additional rooms remaining, then accommodate that person may go against your facility's maximum capacity. And so the hotelier may deny accommodation. And the other one is that if the innkeeper reasonably believes that the person will use the room or facility for an unlawful purpose. And the other one is that if the innkeeper reasonably believes that the person will bring in to the facility something that will create an unreasonable danger or risk to others who are occupying it. So that's the thing we are talking about in this case. So what we are saying, generally speaking, if you are to avoid the liability for refusal to receive a prospective guest, then the hotel must reasonably believe that the person is unable or unwilling to pay, and that person plans to use the room for an unlawful purpose, or that person plans to bring a potentially dangerous object onto the premises. Now, as you've noted there, then the matter of receiving guests is quite primary to the existence of a hotel. But what will happen in the event that a hotel is full? In that case, then, as you have noted, as long as the inn is not full, you must receive guests. But in the event that it is full, then you are discharged of your duty under this under this right to the duty to receive guests. Number two, you may also find cases where a hotel has a sister facility within the same town. Does the law require or demand of one hotel to receive guests on behalf of the other? And the answer to that one is outright no. That an innkeeper may refuse accommodation, to accommodate a traveler in one hotel, and again, they are not mandated to be able to take them to the other facility. And so that is what the requirement here is. What we are saying is that the duty owed by in X cannot be discharged by another hotel on behalf of the common innkeeper of both inns. So if the two hotels belong to the same group, they belong to the same chain, they're sister companies, then there's no way the duty owed to one hotel may be discharged by another. Fine, you may move the clients to that hotel, but it's not a legal requirement for you to do that. You also have a duty to provide refreshment, and this duty is imposed upon the innkeeper by the common law, and so you need to provide the traveler with that, which amounts to reasonable refreshment at any hour of the day or of the night. But again, also, the innkeeper may refuse to provide food and drink if their excuse for doing so is reasonable. Then you also have a duty to provide a safe premises to the people who are going to be occupying that premises. So the hotel will be liable for any harm that may result or damage that may be caused by negligence. And in this case, we're looking at harms like damage caused by other guests, harm or damage caused by the third-party persons, and all those are part of it. But when it comes to natural disasters or acts of God, these ones the hotel may not be held liable, including matters to do with the public enemies and the catastrophic exposures. In that case, the hotel may not be held legally liable. You also have a responsibility for the personal property of the guests to some extent, but only you are all going to be liable for loss of luggage or other personal items that belong to the guests of the hotel that are lost in areas that other than where the guest is expected to be, in the guest room, unless the hotel or its employees are at fault for this. So you are only liable for what is lost while in the private guest room. But whatever else, that one the hotel may not be legally liable for it. U.S. innkeeper has some rights, and one of your rights is right to refuse service, and they have noted that the reasons why you may refuse to offer accommodation. Please make sure that you don't deny accommodation on any matter that may amount to discrimination on racial grounds, on gender, or even on region. The second right that you have as hotelier is the right of lien, and this is the right to detain and the right to detain, and that's a right of lien over any property that is brought into the premises by the guests. But what you need to be able to note again, you as the hotelier do not have the right to detain the guest or to detain the guest vehicle or any other property that is left in the guest vehicle or any live animal that they came around with or even its own harness. So all those, you are not allowed to be able to take those ones. You also have a contractual right. You can enter into a contract with any guests to provide them services. You have a right to receive payment, particularly the advance payment, as a way of proving whether this person is able to pay. You also have a right to control the inn. That's why we always see written that the management reserves the right of admission. Now that emanates from the right to control the inn. And actually part of that is that it allows the innkeeper the right to enter the room that has been given to a guest and actually search it at any time of the day. So that's what we are talking about, that right. You also have a right to evict persons that have already been admitted as guests if they are disorderly, they don't pay for their bills, or they use the premise for any unlawful purpose or act, or they bring to that property anything that may be dangerous to others, or they fail to register as a guest at the front office, or even they came around under false pretenses, either using an ID that is not there, so it's forged, or a minor who is not accompanied by an adult who is registered as a guest, or even if they violate the state law. All those kind of people, you can inject them even after you had received them in the hotel. And so generally speaking, to avoid liability for evicting a guest, the guest must have refused to pay the innkeeper, and the innkeeper must reasonably have believed that the person used the room or premises for an unlawful purpose, or we brought a potentially dangerous object onto the premise. All that will be cases that will give the innkeeper the right to eject the guests who had been already received. I thank you for your listening. Thank you very much.
These televised lectures supplement our robust online learning going on our MKU online platform. You can view more on our televised lectures via our online platform.
We are in a digital era,
and Mount Kenya University knows this. The following are the steps to follow so as to complete your online application. Download the application form from the website www.mku.ac.ke. Attach copies of your academic certificates and ID. Pay the application fees via M-Pesa pay bill number 270988. Your ID is the account number. 2,000 shillings is the charge for a postgraduate. You can also deposit in the bank accounts provided on the website. Then, email all the above to apply@mku.ac.ke.